Thank you for tuning in. This is our next segment in what I like to call the Masterpiece Theater series of real estate videos. And what we've really been trying to focus on in some of these longer, more involved videos are some of the things that can go awry in the closing process, being funded, cash to close, closing in a trust. So we're trying to highlight some issues where people are getting tripped up, and it's ultimately making the closing process unpleasant or less pleasant or complicated or creating drama. I think the next video has to be home inspections in the Commonwealth of Massachusetts because of some legislation that was hotly contested, hotly debated, I think lobbied and legislate, and there was a lot of lobbying and there was a lot of legislative back and forth. But we finally do have a new law on the books, and as a result of this law, buyers are not required to do home inspections. There is not a legal requirement that a buyer conduct a home inspection, but they are strongly encouraged to conduct a home inspection. And the environment has changed in that a seller cannot condition the acceptance of an offer on the buyer's decision or willingness to waive inspection. And there are some disclosure responsibilities that the seller is taking on, some increased levels of transparency and disclosure. So we now have an environment where, as a practical matter, in the early stages of this new legislation, it seems as though most buyers will be opting to get home inspections. Most of the transactions that are crossing my desk currently, in a few instances, the buyer has reserved their right to do an inspection, but ultimately waived it. But by and large, most of the buyers are actually going through the inspection process. And these inspections are producing inspection reports that are being negotiated between the agents. And the final result of those negotiations is that the sellers are making repairs to the property, remediating certain conditions, and that's just all good. I started this video, another video, by saying that in some ways it was a good news, bad news proposition. And just to kind of develop that a little bit, I think it's good news for consumers. It's certainly good news for buyers of real estate because they're going to get more information about the properties that they're buying. I think it's also, believe it or not, I think it's good news for sellers. I think there are some sellers that have been unfairly sued or harassed after a closing about certain conditions that I think, frankly, the seller did not conceal or withhold information. The buyer didn't do a home inspection. They made a conscious decision not to do it, didn't discover something, even something obvious, and then the seller was sort of vilified after the closing for that. So I think sellers also win here because these inspections will be done. Most of these inspection or repair requests will be yes or no questions. The seller can certainly hold the line and say, you know what, I'm not going to fix that. Buy the property as is or don't buy it. So I think that sellers do benefit a little bit here. They get more closure. They get more certainty after the closing is done that they're not going to be in litigation following the closing. I think one of the biggest winners would be home inspectors. These people have been on life support for years because home inspections have really gone away, and now they're back with a vengeance, with a fury. So there may even be a shortage of home inspectors. So that's very positive. So that's good news for all of them. Cynically, I would say, if this is bad news for anyone, it's bad news for closing attorneys and for title companies. And let me tell you why. Whenever we have changes to the law, that usually requires or results in more work for title companies and real estate attorneys. It typically results in our contracts changing. So we have to be involved in that process. And then, of course, there's training of our staff and our team to adapt to the new legal and regulatory changes. And, so and then, of course, there's implementation of these changes, which we're usually on the front lines of that. Don't forget to change the contract to reflect how we're going to be dealing with the compensation of real estate agents. And now the home inspections and also the repairs. So let's talk about that a little bit. And again, it's not bad news for attorneys. It's just more work. And I'm already seeing that on some of the transactions that we've handled. There's a learning curve. And the reason why we do these videos is because we want the closing process to be perfect. Anybody who knows me knows that I am a perfectionist. And I wish that every single closing that we could handle or did handle was perfect. And so when something interferes with that plan, whether it's people bringing personal checks to closing or people closing in a trust but not really understanding what's involved with that, that's when I sit down and I do a lengthy video to try to just help everybody achieve a better, understanding of this process so that we can avoid some of these mistakes. So with inspections, let's break it down. First of all, it only applies in Massachusetts. So I've had people call me up and say, "Oh boy, I've got this, this new deal in Nashua, but this, this home inspection thing." And it's like, well, don't worry about it because it doesn't apply to Nashua. It's only a new law in the Commonwealth of Massachusetts, so it will not affect your New Hampshire and Rhode Island and other transactions. Now, these changes may be coming down the line, but not that I've heard about. So certainly, we're just focused on the Commonwealth of Massachusetts as far as this law goes. It doesn't force buyers to get inspections, but they are strongly encouraged to do so, and many of them are, and so those inspections are going forward. And as a result of those inspections going forward, there are, again, discoveries that are being made, negotiations that are ongoing, and sellers are agreeing, in most of the files that I've worked on, to making certain repairs, whether it's the remediation of mold or the installation of a radon mitigation system or other types of repairs. So this is really altering the landscape because we're going from an environment where we weren't doing inspections by and large. So we didn't have a list of repairs that the seller was going to make before the closing. And how are we going to deal with that? And we just didn't have all this stuff. And now we do. And attorneys in the Commonwealth of Massachusetts, because you have to be an attorney to do a real estate closing in Massachusetts. So we are talking about attorneys. Attorneys are very much involved in that process. And that has been my experience in the very short period of time that this law has been on the books. So let's talk about it. So you are the buyer of real estate. You do a home inspection. And your home inspector tells you that these 3 things or these 30 things need to be taken care of. So your agent will negotiate with the listing agent. And as a result of those negotiations, they'll be like, yeah, we'll do that, or no, we're not doing that. We'll wind up with a list of things. It's typically in a text or an email. These are the things that the seller is willing to do. And so, okay, great. So the seller, sometimes it'll be a concession and the seller won't be doing anything. Now, I'm not going to fix any of that, but I'll give you a $3,000 concession towards your closing costs. Okay, great. So the attorneys have to prepare an addendum to that effect, that there's going to be that credit. But in many cases, it's a list of repairs. And we have to prepare that list. The attorneys are involved in that. Typically, the seller's attorney would start because the seller's attorney is involved in preparing the purchase and sales agreement. So it stands to reason that the seller's attorney would prepare the addendum setting forth the repairs. So the agents feed that information to the attorneys. Okay, well, they're going to fix that railing and they're going to fix that hole in the backyard and they're going to fix that shingle. And then we prepare a repair rider or addendum to the contract. Sometimes we drop these repairs right into the contract. Sometimes we prepare a separate rider to keep it separate. And so that's the first thing that the attorneys have to do is we have to actually catalog the repairs that are going to be made. Now, what are some of the other things that are going to go into that document? Well, we're going to talk about how the repairs are going to be undertaken by licensed professionals or contractors where required. Why? Well, we don't want volunteers making these repairs. We don't want a brother-in-law or a sister-in-law making these repairs. We want professionals. We want the repairs to be done by professionals. What are some of the other things? If a permit is required, the seller will get the permit. If there's a warranty involved with the work, like the contractor says, I'll warranty the work I did for a year. We want that warranty to be assigned by the seller over to the buyer so that our buyer receives the benefit of that warranty. What if there are invoices or there are estimates or diagrams or any what we would call work product associated with the implementation of these repairs? We want the buyer to get all that. And we'll normally put that right in there that the buyer is going to get copies of all warranties and invoices and estimates and repair orders. So what we want is it's not just 2 people in the backyard kind of talking generally about, yeah, I'm going to take care of that and I'll make sure to fill in that hole. It's a little bit more involved than that. We're creating a list. Everybody's signing it, so there's an acknowledgement that this is what's being done. It's going to be done by professionals. We're going to have paperwork behind it. And then we have to make sure that our buyer has the opportunity to go in and inspect the repairs. So we're doing almost like another inspection, but it's not official, and it typically doesn't involve a home inspector. But the buyer is going over there to actually look and make sure not only that the seller did what the seller promised that they were going to do, but also that the seller did it the right way and not the wrong way and not what we would call, sort of a Mickey Mouse job, so to speak. And just to make sure that everything the seller agreed to do was done properly. We have to do that before the walkthrough and before the closing. And so that is the process in a nutshell. That's how that process should unfold. We have identified these repairs that need to be made following the inspection or remediation, mold, radon. The seller has agreed. That agreement is basically memorialized in what's called either within the purchase and sales agreement or in a separate repair rider or addendum. And then that addendum provides for some measures and some boundaries so that there's structure in terms of how the repairs are made. They're made properly, they're made timely, they're made to the buyer's satisfaction, and then the closing can go forward. Now, this video wouldn't be complete if we didn't talk about things that can go awry in the process. And I will say that I think that I want to be positive. I want to be affirmative. So I'll say that we're off to a pretty good start. We have a lot of contracts. We don't have a lot of closings, so we don't have a lot of data in terms of how it's working. But we certainly have had some closings where the seller agreed to make certain repairs, and those repairs were made to the buyer's satisfaction, and the closing went forward uneventfully. But we've had a couple where it didn't really go quite that well too. So let's talk about that. I think people are trying to get their feet wet here, and I think that with some of these transactions, we're off to a little bit of a rocky start. I have seen situations, we just wrapped up a closing, and the attorneys were heavily involved in the resolution of this dilemma. And that's why whenever we have these kinds of changes, I'm always concerned because I know that it's going to be more work for us. And we don't increase our fees or anything like that. Most of this work we're not compensated for. So it's just more work for roughly the same process. But still, in this particular instance, I think we had either sellers or a listing agent that definitely misunderstood their obligations with respect to these repairs. First of all, it was a very lengthy repair rider. So you don't normally see a repair rider or addendum with 25 or 30 different repairs. So that was quite extensive. Normally it's one or two things, easy to keep track of. And in this case, our buyer really wanted to get over there, early to make sure that everything was done, knowing that a walkthrough, which can be fairly brief, really was not enough time to inspect and review all of these different repairs. And they were discouraged and forbidden from doing so. So that was, I guess, the first warning sign. And then when we inquired about who had done the work, just to try to, because we weren't getting any documentation, we were asking for that, we weren't getting it. Our buyer wasn't permitted to go look at it. So there was a sort of mystery surrounding these repairs. So the next logical question was, well, who made the repairs? So let's work backwards. And the answer that was given to the buyer's agent was a contractor. So I think that, I don't know if people were being disingenuous and coy, or if people really didn't understand what their obligations were in that spot. But the law, the good intentions of this law are really being thwarted if the seller who has agreed to undertake repairs as a result of a home inspection, which the legislature wanted the buyer to have a chance to do, there wouldn't be any point in doing the inspection if the repairs that were highlighted by the inspection weren't on the table to be undertaken by the seller, or at least negotiated between the parties. So we don't just do a home inspection, say we did it, and then throw it in the trash. That's a living document, and we're actually trying to do something productive and constructive with that information. And I think that it really thwarts the legislation if you have a seller that agrees to make repairs, but then doesn't do so in good faith, or they don't utilize a licensed contractor, or they don't provide the buyer with sufficient time to review the repairs to make sure that they were done properly, and try to jam that into a walkthrough so that maybe the buyer will miss something or be distracted, or it's just too much to do. So I think that my closing or parting thoughts on this legislation would be that it probably is a good thing. We received a large volume of phone calls in this office from buyers, unhappy buyers that had not done an inspection, felt that they'd been pressured not to do it, that they'd been coerced into not doing it, and then found out all these horrible things about the property and wanted to sue everybody under the sun. We don't want that. That's not good for real estate. So I think that the legislation will cure that ill. It will provide buyers with more information. It's probably good for real estate. It's good for home inspectors. So there's a lot of winners in the equation. But we do need to make sure, whether we're the attorneys that are writing up these documents, or whether we're the agents that are negotiating these items, or whether we're the sellers that are actually ultimately responsible for making the repairs and acting in good faith. If I tell a buyer I'm going to fix the railing and I'm going to use a licensed contractor, then I'm not out there the night before the closing trying to fix the railing on my own or make it look fixed, even though it's not really fixed. So everybody in this process needs to act in good faith and be honest and be transparent. And I think that will just make the law a better law. And I think that it'll be a better outcome and a better closing for everybody involved. So thank you very much for tuning into my video.